president when NORML Canada was founded in 1976. So John is currently our president, still our president. He's very active president. There's like meetings at lower levels. There's Skype meetings and conference calls, and John will regularly join in. He is a very hands-on president. He makes the big decisions and does tons of the smaller work. He's a lion in the cannabis legal community. He went to the Supreme Court of Canada on Insight. He went to the Supreme Court of Canada just recently on Smith. But of course, we all know he's fighting Allard. Allard is the fight for home growing. This could be the template for the future. Whether or not anyone will ever be able to grow a marijuana plant in their home, legal or not legal, it may be hanging in the balance. And there's no more capable captain than John has. He was the one who won the injunction on a potential charter breach. It's a very high standard. John did it. He preserved everyone's growing rights. John is a fantastic president of NORML Canada. He's done a ton. It's a pleasure for NORML Canada to introduce John Conroy.
When you're the lead sort of counsel, you get all the credit. There were lots of other lawyers involved who argued that case and helped tremendously. I'm sure many of you know Kirk Tusaw. He's done some great work. Too bad that he couldn't be here today. We had Tanya Grace, who also argued the injunction part, and Matthew Jackson and Bibas Vaze. So we got a good little core group of lawyers coming up in BC. I'm trying to semi-retire, so I'm hoping that they'll all come on. Because, as you know, I've been in this since the mid-'70s. And it's been a long time. I've seen us come up to the brink of a possible change. I think it's 4 or 5 times now. So this one is interesting. I dug through my bags of stuff that I have at home, memorabilia, trying to think of things to say. And unfortunately, it's a little bit depressing when you read that the Canadian Medical Council in 1971 said that criminalization caused more harm to people, and that as doctors, they were saying get rid of using the criminal law. So, and here we are many years later, and we're in a situation where we have mandatory minimums. When I started practicing, people went to jail for simple possession. I used to appear in a court in Abbotsford, and the judge was a hanging judge by reputation. He used to go down to Sumas, Washington, and drink at lunch, and we knew he was popping Valiums, and then he'd come back and he'd lecture people about the use of marijuana and send people to jail. And so that was the situation in Canada not that long ago. 40 years really isn't that long ago in the big scheme of things. So those are the kinds of things that motivated me, was the hypocrisy that has continued this whole time. And why has it been so difficult to try and get people to listen to logic and reason and rationality? Dan Gardner wrote a good book that I recommend to you. He wrote for the Ottawa Citizen, I don't know if he still does, called Risk. And I think it illustrates the problem that we have, especially on these types of issues that are, you mention the word marijuana to some people still today, and they emotionally react. And so that is a problem. We see it all the time in the criminal justice system. We have a little thing that we do if you go to somebody's place in another town and you say, well, what's the pedophilia situation like in your community? And you'll get this huge barrage of it happened yesterday in the park, and it happened over here, and it happened over there. But when you look at the statistics, it's actually very rare that something like that happens. But getting injured in a car that one of your parents is driving, falling into the backyard pool and drowning, things like that happen quite frequently. And so trying to assess risks and harms, unfortunately with cannabis, it's the topic that, again, there's all this emotional reaction and people don't stop and put their heads in gear and use reason, logic, and rationality. And we know the politicians, the media, the advertising industry, they know this. They know how to push and pull and tweak and get people to react, and that's what we're up against in terms of trying to educate people. People say, as I think it arose with Alan, it's trivial. Why are you engaged in such a trivial issue? Well, why are you using the big stick of the criminal law if it's such a trivial issue? I mean, that's the issue. It's the use of the criminal law for such a benign situation of possession and use of cannabis. So, you know, how do we get people to see, with all the evidence all around them? I mean, we still talk about legalization and decriminalization. Back in the 60s and 70s, we talked about decriminalization as an incremental step towards eventual legalization. And so, you know, what do we mean by these terms? It's evident to me that we all have maybe different ideas of what those actually mean. But I think when we think about what they mean or should mean, because there are just labels for the scene that we want to see happen, we have to think back and say, we've had compassion clubs and dispensaries for 20 years in Vancouver. We've had cannabis around for way longer than that. You know, where is the evidence that warrants this use of the criminal law because of this type of conduct? I mean, that's the bizarre thing to me. I mean, sure, every once in a while you hear of some bad things happening, and there are problems out there. At the 420 in Vancouver, it was reported that 62 people went to emergency at VGH. And the story I heard afterwards was, some of it was magic mushrooms, but most of it was people doing edibles and not being educated about what happens when you have an edible as opposed to smoking, something which is pretty basic, I think, in the cannabis community. And when the Crown in the Allard case got up and said that to Judge Phelan, "Oh, Judge, last weekend there was 62 people taken to emergency. 62 at this 420 rally." 62, said Judge Phelan? That's a soccer match, isn't it? So as far as he was concerned, that wasn't an impressive number. When you think about alcohol and other things in other situations, in terms of what often doesn't get reported, of course. So, legalization. The legalization that I like to see is the federal government stops using the criminal law power, which is its constitutional power. It vacates the field, as we say in our industry. And so decriminalization must mean the same thing. It must mean that we no longer use the criminal law power to regulate cannabis. So I think they both mean the same thing, but only to a point, because of what everybody then puts into the rest of it. So I say, if you want to legalize or decriminalize cannabis, the Liberal or the NDP position, all that has to be done is by order in council. You don't need to convene Parliament. You don't need to do a whole complicated thing. By order in council, you can remove a drug or put a drug in the schedule. So you remove it from the schedule. The cabinet does it. So Trudeau says right away, Mulcair says right away, that's what we've got to be telling them on October 20th if they get in. You said right away, where's the order in council? Don't give us this bull that we need another study or that we need a whole bunch more. You said decrim or legalization. So let's at least see that. So, but the problem is, and again because of the emotional reaction, the fear that somehow people's health or safety will be endangered if we suddenly treat it like a natural health care product. You know? When you remove cannabis from Schedule 2 to the Controlled Drugs and Substances Act, it immediately falls under the Natural Health Care Product regulations under the Food and Drug Act when it's held out for a medical purpose. Otherwise, you can grow the stuff for yourself. You can use it. When you start selling to the public, the natural health care product regulations come into play and tell you what you can or can't do. Richter's catalog. If you go to Richter's, you'll see 3 types of tobacco grown here in Ontario, used as for health and herbal medicinal purposes. And so the emblem for a medicinal thing will be there in Richter's. And if it's a poison that's there because the particular herb might be poisonous, there's a little skull and crossbones. So all the little symbols are there as well as the write-up about what this particular herb does or doesn't do, or is held out to do. And so that's all regulated. Now, that doesn't stop somebody who wants to use any of those herbs. I prefer the term socially to recreationally. They can do that if they want. So why do we have to have, like Washington State, you can only have an ounce. If you got more than an ounce, it's still illegal in Washington State. Did you know that? If you look at many of the different states, we say they've legalized, but when you examine carefully, there's a lot of restrictions. And most of the proposals I've seen, there's a lot of restrictions. And I say, what do we need those restrictions for? Public health is one of the things that's raised. But again, people have been growing and smoking and putting it in food for eons. It was on the pharmacopoeia until what? 1949, at least in England, and I think later in the United States. So, you know, what happened in Holland? This came out in the evidence in Allard. They've had the coffee shop since '76. And they'd run a thriving business. And some people were using it for medical purposes, so they decided, well, we're going to set it up to a pharmacy. So they had specific growers and a pharmacy. And the government looked at this and said, gee, there's about 10 to 15,000, I think the figure was, they estimated, of people who had now decided to go through this route, still under the non-enforcement policy that exists in the Netherlands. You could go up to 5 plants, but if they catch you, they'll take them away. So the government decided to legalize. And so in doing that, they had to put it out to European tender, and the only company that qualified was Bedrocan. The guys who'd been doing it didn't qualify. So what happened? 220 people signed up. Here we are 12 years later. They've got maybe 1,200 people signed up. People voted with their feet and went back to the coffee shops. And do we have reports of health problems from people in the coffee shops? We had studies put in front of the court where they tried to show there was a bit more mold in some of the coffee shop stuff that wasn't in the Bedrocan stuff. But at the end of the day, the researcher had to conclude people voted with their feet and they went back to the coffee shops, and we don't have a number of health problems or public safety problems or issues. So why is there this concern? Well, of course, it comes from the very fact of this criminalization after all these years, and the fears of grow rips and the fears of organized crime and all these sorts of things. But surely, once you legalize and the product becomes abundant and the market can be flooded, then there's far less chance of there being a problem in any of those areas, because the organized crime folks will look for other areas where they can hopefully make money, because you'll take them the profit out, which is, of course, one of the most obvious arguments we've always had for legalization. So that's the kind of legalization I'd like to see, but I fear it's not going to happen. We're going to have an election, and hopefully we will get rid of Mr. Harper. And I have to, maybe as a quick aside, say, because other speakers have all taken a different position on this, I say that the most important thing to do is to look at the people in your riding and decide who's most likely to win. If it's an NDPer, then you might want to vote for that NDPer to make sure that that NDPer wins and the Conservative doesn't. If it's the Liberal, you vote for the Liberal. It's called strategic voting. It's the first point is we are voting against the Conservatives, and we need to do the best thing we can, and that means making that vote count in your riding under this first past the post useless, ridiculous system that was described. But that's what we're faced with, and so we have to try and do that. Lead Now has a Vote Together campaign going on, checking out the ridings in order to see what's best and try to mobilize things so it's a vote against the Conservatives. Because whichever party gets in, we know that there's huge support in the NDP for actual legalization on the troops, the ground people. We know that decriminalization must mean stop using the criminal law. And we're then going to be into lots of discussion and commissions and on again to try and come up with the model. And with the Liberals, the same sort of thing. I think the Liberals in the policy paper that they've put out make it a bit clearer that they understand the constitutional division of powers and that health is a divided field, that the provinces will have a role to play, as will local governments, and so on. So either one is going to be in our favor, but I give Mr. Trudeau huge credit for being prepared to use the legalization word. As a politician, taking it, not only saying it, because my impression from the discussions that I've had with his people and so on is that he does understand it. When I've heard him speak on it, he's learnt things about it. He's not just saying it because he thinks simply he'll get more votes. So I support Mr. Trudeau myself and the Liberal Party, but I say look at it strategically in your riding, and that's most important. Now, I don't know how much time I've got left, but you give me an hour to a lawyer, you know, that's not going to be this rah-rah speech. You're going to get some dull stuff, I guess, that we'll have to sort out. I mention federal government, provincial government, and there's another government, it's local government, that plays a role in all of this. In my practice now, one of the most common things is a complaint about smell. The local bylaw officer or inspector has got a complaint about smell and is wanting to go into a place, often a legal medical grow, to check them out. And I saw just the other day, there's a web page now, I think in the States, that has sprung up of people who are very angry about the smell. And I, frankly, am very sympathetic with those people. I think that if we want to gain the support of the general public for cannabis to be even more mainstream than it's become, we have to make sure we don't stink out the neighborhoods. That's one of the worst things against our side in terms of achieving our objective. People go out in their backyards and they get a heavy smell of marijuana that they don't like. They still have their paranoia about their kids and what influence it will have on their kids, even though we know it's not going to have any. But it's a problem, and it's part of the optics, and it's part of what we have to do in order to continue to gain mainstream acceptance. I brought a couple of books and things to show you, though, how mainstream we've become. Can you imagine National Geographic? For me, that's quite a big step towards mainstream. The other one that I thought was pretty good was Newsweek. You can get this at the airport. So when Newsweek comes out, and I hear the other day Time magazine also, and another...
The current issue of Nature magazine.
Current issue of Nature magazine. I was just told about that too. Apparently has some very good stuff. Jonathan Page, who's a doctorate at UBC, a PhD, he was part of that. Another really important thing is this American Herbal Pharmacopoeia. I don't know if you know, but cannabis was on the medical pharmacopoeias in England and the US and so on up until mid-50s anyway, and sometimes early 60s. And it's only this demonization since the early 60s that's really been the cause of the problem. So anyway, it's now back on the American Herbal Pharmacopoeia. You can get this at their website, and it's a very informative document about growing cannabis and producing cannabis, including discussions about different pesticides and all the rest of it, that are some that are acceptable and some that aren't. So I recommend those things to you. So a couple of other things to comment on. As you know, cannabis, as I said, was legal right up until 1923 in Canada. And then only because back in the early 1900s, after the Brits and the Turks and others traded all these things into China in exchange, they traded opium in exchange for various products. The Chinese developed this opium habit, and they all came to Canada and to California and built the railroads, many of them dying in the process, and were extreme hard workers, but they had the opium habit. In Vancouver, Victoria, New Westminster, we have opium dens, and then we had a labor surplus. And so white guys started complaining about yellow guys taking their jobs, and white women being seduced in the opium dens by yellow peril. And that led to race riots in Vancouver, and in the result, Mackenzie King, who was Minister of Labor at the time, was appointed to have a royal commission, and they looked into the riots and the damages and the claims for loss of opium product, and they came up with our first Opium Narcotic Act. And it was all about getting rid of the Chinese. If you go to the Dominion Annual Review of Statistics for that period, you'll see Chinamen deported possession of opium product. It wasn't until 1923 that cannabis was then put in the schedule. There was no cannabis problem going on in Canada. There was hardly any knowledge of it. It all came from sources such as the Black Candle, Janie Canuck, Judge Murphy, Emily Murphy, and those types of sources from the U.S. Because in the U.S., going back to before 1923, there was a roll of these states from the east through to the west criminalizing cannabis. The feds in the U.S. didn't do it until 1937. And so I mention this only because I do think that the roll is going back the other way, and that hopefully this time it's going to roll completely back the other way, and we'll finally see an end and have some reasonable regulation of cannabis. We've got state after state in the U.S. We've got at least somewhere between 23 and 30 medical states. We've got now, I think it's 6 or 7 going full legalization. And so there is a role. And they're not going to undo Colorado. They're not going to undo Washington State. So it is going to change. Even though I was depressed reading some of the old stuff for each time that we came up and hoped to succeed, I remain optimistic. I remain hopeful and optimistic that we will turn the corner. It isn't going to be over, though, just because we take it out of Schedule 2. There's still going to be this huge struggle to make it reasonable, to stop the excesses that people still will want to put on it, in my view. Let me say a quick word about driving, because I think part of this is educating, hopefully, you so that you know what to say to people when they raise this issue, particularly between now and Election Day. If they say, oh, we're just going to have a huge pile of people out there driving more impaired. Well, and we don't have a magic machine to figure it out. Well, they made a big mistake, I think, in Washington State. They've set 5 nanograms as the presumed impaired limit, and it's irrebuttable. In Colorado, it's the same, but it's rebuttable, is my understanding. To me, that's nonsense, and to NORML USA and NORML Canada, that's nonsense too. You can't judge a person's ability to drive simply because you register that they have consumed cannabis. It doesn't work that way like it does with alcohol, where they have a specific offense of driving with a blood alcohol level in excess of a certain amount. So the law in Canada that still exists is called impaired driving. You shouldn't drive while your ability to do so is impaired by alcohol or a drug. So how does one determine whether one's ability to do so is impaired? You have the person step from the vehicle, if it's a roadside check or roadblock, or if there's been some reported weaving or suspicion or whatever it might be, and you have them perform roadside tests. Roadside tests that go to determine whether their motor coordination skills are problematic or not. And you can now have it videotaped from the police car, so there'll be no dispute and less clogging up of the courts and arguing about whether the person walked the straight line or touched his nose properly and these sorts of things. And officers are trained and have been since as long as I've been practicing to do these things. And that's how they enforce the impaired driving law, or subject to what some detailed changes in BC, which I won't get into. But basically, you know, that's the answer, isn't it? We have a law. It's a valid law. We don't encourage people to drive where their ability to do so is impaired. And there is a way that's been tested and used by the police for ages that's been effective in terms of that particular issue up to a point. Now, the problem's even more complicated with cannabis, because I've discovered through being involved in the medical end of it that there are many patients who consume large amounts of cannabis and they're not impaired. Their ability to drive isn't impaired at all, because it's kind of become a normal thing for them. And so what I recommend to people, and you can do this, I know, in British Columbia, I hope you can do it in other parts of the country, but you can actually go to the Insurance Corporation of BC, ICBC, and they will do some tests for you of your motor coordination skills under different levels of cannabis in order to determine a baseline. and assist in terms of that whole issue. I just heard about this last week that I've been trying to refer people to private sources to do that, so that if they are stopped, they can give the officer something to show that just because they smell of marijuana or whatever, there is another side to the story, instead of assuming immediately that the person's impaired and so on. So, you know, there is a solution to the impaired driving thing. There's a solution to the smell thing, I think, too. I mean, charcoal filters is the main thing that people use, and I think people forget to replenish them or something. But I know that the Cadillac version is the air conditioners with the sealed room. In Allard again, Remo Colasanti brought into the courtroom a bloom box. So I never realized how big these bloom boxes are, but this is the engineered solution. You can bring in the bloom box and put it in an apartment, and it does everything, and it's fire and electrical safe and all the rest of it. So that's one of the modern marvels. But he also gave evidence about how you can do it in a bloom box all the way up to the fancy Cadillac room with the air conditioners and the sealed system and so on. And I know he lives in a residential area in Maple Ridge, and there's no smell whatsoever coming from his production facility. So there are ways and means of trying to solve some of these problems. Teenagers and children. And obviously this is one of the main areas that provides this emotional reaction. I think, you know, we know that the law started as racial prejudice, but obviously it's sort of got a health base nowadays. But the business of trying to overcome people's emotional reactions, a lot of it seems to have stemmed in more recent years. Maybe it always was there, but it's come out a bit more, is this fear that it was a gateway drug. And that if the teenager started using it, that, God help us, you know, the society would go to hell in a handbasket. And so, and then recently the study, flawed study out of New Zealand that suggested that all kinds of damage to teenage brains, I think it was, something along that. And it determined they hadn't eliminated all the co-founding variables such as consumption of alcohol, a few things like that. But again, you get stories like that, and the colleges of physicians and surgeons come out and they say, oh, you shouldn't prescribe any marijuana to a patient unless they're over 25, because their brains will be damaged until they're 25. You say, will their brains be damaged by sending them off to war before they turn 25? Will their brains be damaged by allowing them to smoke tobacco at 18? Or to drink alcohol at 19? I mean, there's all kinds of things that happen in life that can affect our brains. And yet they've got the College of Physicians and Surgeons saying something like that. You know? Meanwhile, we've got all this publicity of late that shows that there's something in cannabis, and particularly the CBD, that stops seizures. And we've got kids with horrible Dravet syndrome and other types of things that have benefited from it, and it's stopped their seizures. I've heard, but I hesitate to say this, but I heard, I haven't seen the study, but somebody finally is admitting, and this is a big step, because most of the evidence that I've heard and read about in terms of medical is symptom relief, not cure, but that there is some retardation of cancer, some type of cancer cells, some recent study. If that's true, that's a huge step in terms of further understanding of what the cannabinoids can do. I have to say that taking on that case, you know, 38,000 patients out there, my email and everything went nuts, and it's pretty crazy still at times, but the stories that I've heard are just absolutely unbelievable. If we'd had, you know, a huge funding resource, we'd still be calling patients to tell their stories, you know, because we could have gone on forever. We deliberately chose 4 plaintiffs in BC for cost reasons. because we weren't going to be able to afford, we didn't think, to bring people from all over. So it was, let's try and pick, of the huge number of letters and emails and so on that we got, people that fit the various categories that we think need to be covered. And so that's what we did. Now, as you know, and I should talk a little bit about Allard. It's so basically a constitutional challenge. It's not a class action in the traditional sense of the word, but it's a constitutional challenge to the MMPR, the Marijuana for Medical Purposes regs, the new regs, saying that they're unconstitutional because they failed to include the person's ability to produce for themselves, or what it's more limited than the DG, a true caregiver to be able to grow for that person. And so we say that that is the constitutional problem with the MMPR, and that should be legislated in. So if we succeed, the dried marijuana is in there too in terms of the narcotic control regs and the MMPR, and the 150-gram limit thing that was imposed in the injunction. We were challenging it in the MMPR, and it was suddenly imposed upon us, and it's a ridiculous thing, but anyway, it's there. So those are the basic issues, and I thought that the evidence went in very well. I thought that at the end of the day, things look pretty good for us. In this business, you never know. You often think that you've got a great case and you're just blown away by what the judge ultimately comes back with. But I think it went in well. We did at least have the injunction, which unfortunately, again, he picked dates that I'm still puzzled by why he picked separate dates. And unfortunately, Judge Phelan wouldn't change or vary it at the trial. We chose to argue that in front of him because he was the one who had all the evidence in front of him that hadn't got in the Court of Appeal. But we now wait his decision. And if his decision is in favor of the plaintiffs, and he declares the MMPR to be unconstitutional to the extent of failing to provide an ability to grow for yourself or have a caregiver grow for you, if he makes that declaration, then I would expect I would hope that he would be open to varying and expanding the injunction at that point, because it's probably one of those situations where he will then give the government a period of time, suspend the declaration, and give the government a period of time to try and fix it up. We were lucky in Smith to be able to succeed in convincing the Supreme Court of Canada that that wasn't one where they had to delay, suspend, and so on. And there was some very good submissions made in Smith dealing with that whole issue, but I think that that's what would happen in terms of growing and so on. It may not happen if, in terms of the dried, he may right off the bat say, well, based on Smith, it's also unreasonable and invalid under the narcotic control regs and the MMPR. And hopefully he'll also do something like that with a 150-gram limit. But the key points about growing for yourself or having a caregiver do so, that's that scenario. Now, I would expect the government, unless we get rid of Harper, October 19th, and maybe get political masters who say legalize and decrim and instruct the Department of Justice to tell the people in health to pull back. Am I being optimistic? That is a scenario that could be and would be the best scenario for all of us if they said, stop, let's sort this out, let's make this reasonable. Of course, he could decide against us. And if he decides against us, then we're going to have to appeal. And not only are we going to have to appeal, but we're going to have to move to stay his judgment pending appeal so that it doesn't take effect right away. So that all of the people currently protected by the injunction hopefully will continue to be protected by the injunction. And then everything goes to the Federal Court of Appeal, and from there possibly to the Supreme Court of Canada. If it could move as fast as Smith, that would be great, but I don't think that's as likely. The issues are a little more complicated, and the evidence probably much greater in terms of volume. So those are scenarios that we're likely to face, and the only way we can try and minimize or reduce them or eliminate them is to get rid of Harper October 19th, and then at least have a shot at maybe having something more reasonable. How am I doing for time? Do you want to do that now, or do you want to do it? There was some discussion about doing it later, but I'm open. Okay. All right. Let me then quickly just touch on a couple of other quick points. One area, criminal records. Please, whatever you do, and I think some of the parties have come out and said they will get rid of the criminal records, but you got to remember nowadays, sure, there's a criminal record under what we call the CPIC, Canadian Police Information Computer. That keeps record of a conviction, a dismissal, but also a stay of proceedings and a withdrawal. And people are currently prejudiced by having stays of proceedings and withdrawals on their records. But what's even worse is that nowadays everything goes into a database. And there are now a large number of computer databases, and if you've been stopped in a car in which your friend had a joint on him and you happen to be the driver, that's going to be in the database when they plug in your name. And so what's grown up is you've got companies, instead of seeking criminal record checks, which would be limited to the actual conviction or a dismissal or the stay or withdrawal, which are offensive enough, they get a police information check. And you sign and you consent to having all these databases checked out, and they come back with this huge amount of material, of allegations or just associations or circumstances. And I've even had cases where they refuse to give me the names. They say, you're associating with these organized crime, your client's associating with these organized crime folks, but they've blocked out the names. So we don't even know who they're saying or who they're talking about. This is, in my view, becoming a major problem. So if we have legalization or decriminalization, there has to be, a part of it has to be a complete wiping out of every, not just conviction, but stay, withdrawal, information in police data banks anyway, hopefully, so that there's no ongoing prejudice. I suspect that's one of the things we'll be fighting for a while. Anyway, so employment is another issue that's coming to the fore. People getting dismissed simply because they've got medical marijuana cards, things like that. I'm not totally up on that area of the law, but I'm becoming so. There was a case in Vancouver, I think just the other day, where an alcoholic drank off the job and lost her job, and the courts have quashed it and said the employer had a duty to accommodate. So that there may be, it's an area that's obviously, with legalization or decrim, is going to be an area that we'll have to pay some attention to. A quick word about the dispensary issue. Vancouver, I act for the BC Compassion Club Society that was incorporated 18, 20 years ago. Hilary Black, Rael Kapler, and they're a true compassion club, so it's a membership-based thing. And the city of Vancouver has come up with a bylaw that is split between compassion clubs, and it's a bit of an interesting definition, but it does still say medically related dispensaries. And there's a huge variation in the licensing and so on. But to their credit, they've said, boom, we've got all these dispensaries. We need to regulate the zoning and use to some extent to the best we can. We can't just ignore it. And by the way, I think this is what happened in Holland is what's happened here. People went to the LPs. They got their first supply. They're forced to rely on a web page, I think. Many sick people are older, they're on disability pensions, they don't have computers, they aren't, some of them don't have credit cards. And the system the government's designed is just not user-friendly to them. And so they've been on waiting lists, and they've got to go back to their doctor, get another medical document if they want to try another LP. And so I think they voted with their feet, as the people did in Holland, and went and said, I can go to a compassion club or a dispensary. I can talk to people. I can look at it. I can feel it. I can hear anecdotal evidence about it, you know, instead of maneuvering this unworkable system. And it's not the LPs at fault. It's the government, again, for coming up with a system instead of realizing that we've got LPs, we've got dispensaries, we've got compassion clubs, and we've got individuals producing for themselves or having caregivers do so. What's the problem with that? Local government has the role to play in terms of zoning, in terms of fire, electrical safety, smell. All of these things are for local governments, you know, and they're getting well experienced at it and developing, you know, solutions. So just a quick note about that. Now, I'd just like to say then in closing before taking questions that I'm really pleased to see the women's involvement. Wasn't it Hillary Clinton who said that it was the unfinished business of the 20th century, women's equality? So, and I said to Tracy, there aren't only women acting badly. There is Chief Justice Beverly McLaughlin. She's been around for a long time. She's 71 and still going strong. And she's led that court. All of these cases that have struck down this ridiculous conservative criminal law legislation, mostly, has been under her leadership. So people listen more to women than us men. We need the women. We are at a historic time, and hopefully we can get all our friends and neighbors out there, and let's get rid of these guys. Not just in cannabis area that they've done a lot of damage to Canada. You know, the Charter of Rights and Freedoms in 1982 was brought in by Pierre Elliott Trudeau and Jean Chrétien, and it has saved us from a horrible situation. If it wasn't for the Charter, if we hadn't become a constitutional democracy in 1982, we would be in serious trouble. Thank God for the independent courts who have stood up to this stuff and struck it down as being unconstitutional. Very few places in the world that you can do that. You can do it in Canada.